Okay, so my name is Justin Stivers. I am a probate attorney. I own the Probate Law Firm. Our office is in Brickell, 1395 Brickell Avenue. We do exclusively probate, so I don't do title, I don't do evictions, I don't do real estate. It's exclusively probate and then the planning side. So I'll touch on the difference between that here in a bit. We're active in about 17 different counties throughout the state of Florida right now. And I started doing this presentation probably about a year ago because I find that realtors are coming across probate properties a fair amount. And I think just by the nature, Florida is a retirement, old person state. So chances are you're gonna come across a property that's owned by somebody who's passed away. So the point of this presentation is really not to make you all experts in probate. It's just to help you identify if a property is going to go through probate, how to speak to the potential buyer and or seller so that you kind of stand out from the crowd, because there's no secret. There's a ton of realtors out there. So if you go in and you can kind of just speak the language a little bit, and in my experience, I've had realtors that either on either side, either we've referred it to the realtor, or the realtor has referred it to us. I know the client is kind of blown away just if you can explain what probate is, because most people don't even know, and truthfully, a lot of attorneys don't know what probate is. So it's a very unique thing, and if you're able to just kind of say some of the basic stuff, you're gonna be leaps and bounds above the 50,000, 60,000 realtors there are in Miami-Dade, something ridiculous. And then also, I'll give you guys a couple marketing ideas of how to market for and find probate listings. So that's me real quick. Since we're like a small group, and for you all who didn't make it, you RSVP'd, you should have been here. Maybe we'll start, and just tell me, name, how long you've been a realtor, what area you focus in on as far as, listings, buyer, or what areas of the city or the county, and then if you've ever had a probate experience and what that has been like. So I kind of, can tailor this, because we'll make this very conversational. If you all have any questions whatsoever, it's probably only going to be about 30 minutes or so. We'll start with you.
Okay. My name is Cynthia Griffin.
Lydia?
No, Cynthia.
Cynthia, okay.
Cynthia Griffin. I focus on Miami Beach and surroundings, Miami Shores, Pearl Harbor.
Okay.
I've only been in business in the U.S. for 3 years.
Okay.
So I'm fairly new. And I've come across 2 probate cases. One that was my house sale. It was a small sale, and basically the owner didn't know that she had to go through probate courts to sell her property, and the listing agent listed it and didn't know as well.
Very
So
common.
surprised.
That's very, very common. Yeah, absolutely. But was it a difficult process after that, or?
No, it wasn't.
Okay.
Very difficult after that. It took
Okay.
about a month
Okay.
longer.
Okay, gotcha. Not too bad. Not too bad. Okay. Yes, sir.
So my name is Chris Dreyfus. Focus really on Miami Beach, and let's call it maybe 8-10 mile radius.
Okay.
Going down from Brickell up to let's call it Sunny Isles and
Okay.
so on. So I've been in real estate now for 5 years. I was in technology sales for a very long time before then, and my experience with probate, frankly, I really don't have any.
Okay.
I have not gone through a sales process A to Z
Sure.
with probate involved. I have called on some listings that my understanding is that we're going through the probate process where a buyer was interested in that, but I really never got far enough along the process
To learn it.
to really learn it. So this is great information.
Cool. And what kind of tech sales did you do before?
Identification. So Apartments offered to provide solutions based around biometric technology and smart card technology, things that make driver licenses and things like that. So
Interesting.
a whole different world.
Yeah, definitely. Still sales. We're all in sales to some
It was
extent.
definitely sales.
Yeah. Okay. Yes, sir.
Clemente Sanchez, I've been in the business for 20 years.
South Beach, especially South of Fifth, Gables, Pinecrest.
Which is where I live right now.
Okay.
My family.
Great.
Never been through probate in 20 years, maybe a coincidence, but
Yeah.
never had to deal with it. It sounds interesting, and it's something that I always think you need to be prepared for.
Training circumstances, because it's still business.
Yeah.
And you gotta bring it to you the best way you can. And if you are prepared for it, you could offer
Yeah.
an advantage.
The way to present yourself.
Yeah, I think that's a common thing where I have realtors who maybe in 20 plus years of experience, they never come across it, but then you have a realtor with 3 years and you've come across it. So there's no rhyme or reason to it because there are ways that you can specifically target probate properties, and I know a lot of realtors, and I only know one realtor who she's focus is only on probate, and I can tell you how she does it, and I tell a bunch of realtors, and still no realtors have tried to compete with her, but I think it's such a great space to get into, and I'll talk about that a little bit. But there's really very few realtors who target specifically that. It's just, chances are it's gonna happen. You think about the baby boomers, here on the beach, a lot of older people living on the beach, Sunny Isles even, a little bit newer, Sunny Isles a little bit newer, but there's still pockets of Aventura and different areas where there's a lot of, older, retirement people, and that's gonna lead to probate. And so we'll start with what is probate, just so that you all know. It sounds like you kind of have an idea, but basically probate, the triggering factor that makes probate happen is someone has died. So somebody has passed away. So it is kind of a sensitive topic. I try to make it lighthearted as much as possible because, for better or for worse, if someone dies, I kind of get excited because it might be a case for me. So it's a little morbid, I know, but but we're doing a good job. We're helping people out with it. But basically, someone has passed away, and in your world, in the real estate world, what that means is usually, let's just say, John owned a piece of property. He's now died. His children want to sell the property, or maybe they just want to live in it and they need to get homeowners insurance on the property. They want to keep the homestead exemption. They need to transfer title from John's name into their name. And the way they do that is they go through court, and a judge at the end of the process is going to say, okay, now John's kids are now the owners of the property. And so that's the nuts and bolts of it. When you hear probate, you're just going to think there's got to be a court process. There's going to be judges, there's probably attorneys, and you're just getting title into the right owner's name so that they can either buy it or sell it. That's kind of what probate is. A couple other terms that we'll use, personal representative. That's probably a very important term. Some states use different terms. They might say executor or administrator. In Florida, we use the term personal representative, and that's the person that you all would be working with. So if you're the seller, if you're working with the seller, you need to be working with a personal representative. And what that person is, that person was named by the court. Again, the court, the judge has to say, okay, now you are the personal representative. That's the person who's going to sign all the closing documents. That's the one who's going to sign the listing agreement. That's the one who's going to sign the as-is contract. So it's very important that you work with that person. And again, a personal representative, just because they're the only child, let's say John had one daughter, Sarah, and Sarah comes to you and says, Chris, right? Chris, I'm the only daughter, I'm going to inherit this property, I'm the personal representative. If you don't have a piece of paper from the judge saying that Sarah's the personal representative, she's not yet the personal representative. So very, very important thing to know. A couple other terms we use, last will and testament. Have you guys heard of, this is pretty common, but a will, what a will is?
Yeah.
What's a will?
A will is somebody creating a testament before they
Pass.
Yeah.
And they
address the people that are gonna get the belongings.
that he's lifting behind.
Yeah, perfect. So basically, it's a piece of paper that says, I'm leaving all of my assets, I'm leaving my house to my wife, I'm leaving my car to my children, whatever it is. It's a piece of paper. The piece of paper is probably also going to say who the personal representative is. One thing I get asked a lot is there's not like a database that I can go, or anybody can go look at and find a person's will, because I could create a will, there are some rules of what make a valid will, but I could draft a will here in the office, give it to you all.
Excuse me,
Hi,
I don't
come on
know
in.
you.
We're just getting started.
My apologies, I came from the doctors.
No, you're fine. Have a seat. But I could create this will. I could draft this. I could put it in, in this drawer here, and nobody's gonna know about it. Yeah.
Excuse me.
Yeah, sure.
Does it need to be notarized? The will?
So
To be valid?
no.
No.
Generally, no. It does not need to be notarized. There are the main requirement is it needs to be signed by the person at the end of the will, and there needs to be 2 witnesses.
Okay.
There needs to be 2 witnesses,
So
and they all
sign
need
two
to
witnesses.
and they all need to sign at the same time. There's some other requirements, but generally no, it doesn't have to be
They get
notarized.
signed.
Um, One thing about wills also is they don't avoid probate. So that's a big misconception that someone will have a will and they'll go, let's say they leave it to you and they say, okay, you're let's not use a real person, but let's say John has a will, his dad left the property to him in his will, John goes to the property appraiser's office or whatnot, he says, look, my dad left me this property, here's the will. The court, the property appraiser is going to say you still have to go through probate. So you can't avoid probate with a will, and that's just kind of a common misconception. A lot of people think you can. But a will, we talked about that. And then the last one I'll mention, last kind of definition I'll mention is estate. So E-S-T-A-T-E, estate. That's what we call basically everything that's now owned by the person who passed away. So again, using John as an example, when John was alive, he owned his house, he owned his car, he owned his jewelry, whatever else he owned. Now he's died, so now everything that is owned by the estate of John. And that's just a term, estate is what we use to call everything that John owned at one time.
So that's why the famous estate sales and stuff like that.
Yeah, so that's why you have an estate sale, basically. They're selling all the stuff that John had. Yeah, exactly. Any questions on that?
The ways to get around probate would be to set it up in a company and have other officers, or as well as a trust, etc. Those are the ways to get around.
Yeah,
Probate.
great example, and I'm going to answer that in like 2 seconds.
Okay,
It's a good segue. So, all right, so now what I want to show you before I get into how to avoid probate is how to identify a property that might need to go through probate. And again, so the purpose of this kind of conversation is not for you all to go out and practice law and try to be probate attorneys, because you're not. You're realtors. But the point is so that you can provide valid information to the client and then also make a smooth transition. If they don't have an attorney, or if they do, you get in with that attorney and you can work with them and just kind of, solidify yourself as the client's realtor. So what might start triggering, so first you want to figure out if the client you're working with, the property you're working with might have to go through probate. Because the example you gave, the listing agent didn't know, no one knew until probably title said, hey, you guys got to go back and do, or when did they find out?
No,
Title told you, right. So when you guys get a new listing, probably or a potential new listing, probably one of the first things you do is you go to the property, the tax county, to look up the property, to see who the owner is. So I have an example that I gave you all. The first one you'll see should be owner. If you look down, it says Maria Pichardo, EST of, property address 11309 Southwest 200th Street. So this is the easiest way to figure out if it's going to go through probate. After the owner of Maria Pichardo, you see EST of. So EST stands for estate, which we were talking about earlier. So this property, let's just say 96% of the time, it's got to go through probate. Probably 99%, truthfully. But if you see this, your mind should automatically be thinking, okay, Maria has passed away, her property is now owned by her estate. Before we can sell this property, we've got to do a probate. So this is one that we did. Now, if you were to look at this, it should say owned by her daughter, because her daughter was the only heir, and now the property is in her name, and she can sell the property. So this is one of the biggest ways. This is a very common way that you'll find out, you'll kind of identify if a property is going to go through probate, is by seeing that EST of after the name.
Any questions on that one?
Pretty simple. All right, the next page, if you flip over, 1821 Northwest 33rd Street, Jesus Silva, EST of, and Midas Silva. Okay. This is almost identical to the example that you gave us a second ago. So this, Jesus was the dad, Midas the daughter. They own this property 50-50. Jesus, we see that EST of, so that should notify us that it's got to go through probate. But here's what happened on this one. Maida was the only daughter. Her dad died many, many years ago. She wants to sell this property. She gets a realtor. The realtor sees it. I don't know the conversation, but Maida says, this was my dad's property. Him and I owned it, so now he's passed away, I wanna sell this property. So they market it, they go through all of this, they get a buyer, spend, 4 or 5 months trying to sell it, they go to the closing, title company says, hey, you've gotta go through probate. She thought because they owned it with her dad and she was the only beneficiary that she just automatically inherited it. But the property was 50-50, and without getting too much into the title side of things, it was what's called tenants in common, which basically just means when Jesus died, he kept 50% and she kept 50%. So this is pretty common here in South Florida, where you've got people who own a property either as business partners or maybe as siblings, and they don't do the deed in a way where it would pass automatically upon death. And I'll talk about ways you can do that. But you might see this, and so if you see something like this, if you see that there's that EST of, or if, let's say you were talking to Maida and she said, hey, my dad passed away, he was on title with me, you should do a little bit of digging, not just go right, probably what happened is this realtor just said, oh great, potential listing, I think it ultimately sold for, I think 400,000, right around there. She probably saw the listing and was like, great, let's just sell this thing, get it on the market, without really spending probably 10 minutes. Had she called, a probate attorney or looked into it, it could have very, very easily been figured out, no, before you can do anything, we gotta go through probate on this one. So, my suggestion is whenever you see that EST of, or really whenever you hear that someone's passed away, you should kind of start, thinking maybe it's a probate one. Yeah.
Now that will be different than a husband and wife.
Husband and wife is different, so now I'll transition into your question. So how could you have avoided it, and what are some ways that it wouldn't have had to gone through probate? So generally, husband and wife, if you're on title, it's gonna say as husband and wife, or it's gonna say tenants in the entirety, which what that means is when wife dies, it automatically goes to husband. When husband dies, it automatically goes to the wife. And so you're not gonna deal with probate. Now, when they both die, if they didn't have it done in a way, the children or whoever they leave the property to might have to go through probate. But husband and wife, you don't have to worry about it. So if if I die, my wife automatically gets the property. We don't have to do it. She wouldn't have to do anything. Now, one way to avoid it is if we look at the last handout I gave you. So 13926 Southwest 161st Court, Karen S. Rodman. So if you see that TRS, that means trust. So and then under that, the BEN means beneficiary. So there's Karen S. Rodman, and then I believe it was her daughter, Karen Rodman, not the same person. So basically what this means is a legal document, which is not a will, it's called a trust, was set up. Karen, in her trust, said, when I die, I want my property to go to my daughter, Karen Jr. Then they had to take an additional step and actually change the deed. So that's one big thing that first let me back up. A trust is going to, when done properly, if you put the property in the name of a trust, it avoids probate. So when Karen passes away, her daughter doesn't have to go through probate. It's automatically gonna go to her because it was set up in a trust. Now, one thing where I see a lot of mistakes is either you do it yourself or your attorney or whoever, someone does a trust for you, okay? So let's just say I create the Justin Stivers Trust. I've got my property 123 Main Street. I don't actually change the deed on the property. So the property is still owned by me. 123 Main Street is still owned by Justin Stivers. Well, to actually avoid probate, I need to change the deed and put the name of the property into the trust of Justin Stivers. So I need to basically do a deed from Justin Stivers myself to the trust of Justin Stivers. Because if I don't do that, the trust is pretty much worthless. It doesn't do anything. I know it's kind of complicated, but it's something I see a lot that sometimes people forget that step where their attorney does, it just falls. They think, I did the trust, I'm good, so they got the trust here. But if you don't update the deed, like if this didn't have the TRS or the beneficiary, if this just said Karen Rodman, but she still had a trust, the trust is worthless. It wouldn't avoid probate. So.
How long would it take to do the change?
Oh, same day.
Oh, really? Something very quick?
Yeah, that's simple. It's the same as recording the deed. You go down or record it online. It doesn't take long.
Justin, when you do the transfer of the deed to the trust,
Would that affect?
in any position, the way your property has a homestead exemption?
It shouldn't. No.
It should.
It shouldn't. No, it shouldn't. Now, I'll say that depending on if there is a mortgage on the property, So if there's a
Like I
mortgage,
say, I have my house, which,
Right.
is paid off, and I have 2 daughters that live with me.
right,
The house is on my name, and God forbid something happened to me,
You know, or that had to be done.
in the way that the
Homestead exemption was
still,
enforced.
well,
Or you
if you do the transfer to the trust,
so the trust shouldn't affect the homestead exemption while you're still living, okay? I think even this one, if we look, it looks like she's still claiming homestead exemption, that first one for 50,000.
I was looking at that, that's.
It's a little
my
different,
question.
it says county exemption, but I think that's still a homestead exemption. But it shouldn't affect the homestead exemption. Where it would affect the homestead exemption is, let's say you did a trust, okay?
Yeah.
You put the property in your, cause you do the trust while you're still alive.
Yes, no.
And so you say, trust, I am the owner of the trust and I'm still alive, property is still mine. But when I die, I want it to go to my daughter. When it goes to your daughter, she might lose the homestead exemption because if she's not living there. So,
Although if
does
she's
that make
living
sense?
there, or she would.
If she's still living there, she would need to, now she just has to apply for the
Apply
homestead
for the
exemption,
homestead
right?
exemption.
But if she's living in Tampa and you just want her to have this property and she wants to keep it as a rental, it's like any other thing, yeah. So the homestead exemption, you'll still carry it while you're alive and it's in the name of the trust, but when it goes to her, if she's not living there, she could lose it. So trust is probably an easy way to, if done properly, is an easy way to avoid probate. The other way two other ways is with the deed. So, sorry, how long have you been a realtor? Just so I know.
20 years.
Oh, okay, so seasoned. All right, we got a veteran here. All right, so another way is if you do the deed with joint tenants with right of survivorship. Has everyone heard that term? Okay, so if you do it, and that would show up on there, it would say JTWOS. That would stand for joint tenants with right of survivorship. You would see that on the deed. If Maida, in that last example, if Maida and Jesus had that, if they had the deed as joint tenants with right of survivorship, when Jesus died, his would have automatically gone to Maida and they wouldn't have had to do the probate. So that's an easy way to avoid.
That is what happened basically when a married couple.
It's the same as like married couple.
Automatically goes.
Yeah. Yeah, it's just you don't when you're married you don't do it as joint tenants or right of survivorship. It's called joint tenants with entirety. But when you have, let's just say friends or brothers and sisters, you would do it joint tenants with right of survivorship. And then the other way is,
Excuse me,
go ahead.
when you buy, you are not into it, you don't do it right. Can you change it later on?
Yeah,
You can.
you can change it later.
And it's also a one-day thing.
Yeah, it's really, it might take them a day or two to actually record it and update it on there, but you can go get it recorded and they'll give you a stamped copy of it that same day. Another kind of easy way to do it to avoid probate is by doing what's called a lady bird deed. Lady, L-A-D-Y, lady, and then bird, B-I-R-D. If you go to my website, I have a really good article on it. Our website is probatefirm.com, but we have a good article on lady bird deeds. But anyways, what that is let's say I own a piece of property and I want my children to get the property when I pass away. Okay, or me and my wife have a piece of property, we want our kids to get it when we pass away. But we don't want to do a trust because a trust doesn't fit for everybody. Sometimes they're more expensive. There might be reasons why you don't want to do a trust. But we want our kids to get the property when we pass away. We can do what's called a ladybird deed, where we put them on the title right now, so they would see it. Their names would appear on there, but they don't have any ownership interest right now. They can't sell the property. If me and my wife want to sell the property, we don't need their permission. But when we pass away, the property automatically goes to them without probate. So it's a unique thing. Only 5 states have it, and Florida is one of them. And it's a great tool that you can do.
What is the name from?
So it's from Lady Bird Johnson, the wife of ex-president. Good question. Yeah, I just learned that recently because I
remember Lady Bird.
You knew that? Okay, yeah.
I remember her name.
Yeah. I don't know why though. I don't know why like why it was named after her, but that's who it was named after. But anyways, that's a great tool, and so that's, you know, for example, we generally do those for like $495. It's a little bit cheaper. Sometimes most trusts that we do start at like $1,100 more or less, just to give you an idea. So sometimes it's a more cost-effective thing to do than a trust. So sometimes, you know, people, if they just have one property and they're like, my kids are gonna get it anyways, I don't wanna spend, you know, $1,000 or whatever doing it, I say, well, do you wanna save them money on probate? And sometimes they're like, no, I don't care. Sometimes they're like, let my kids just deal with it.
They're gonna get it.
Yeah, they're gonna get it, they don't really care. But sometimes they're like, okay, yeah, let's just do the deed. So it's a good way, it's a relatively easy way to avoid probate. So, but again, wills do not avoid probate. So those are the
I'm sorry,
easiest ways.
Can you do this, Lady Bird, also with other things other than real estate, or it's only for real estate? In other words, furniture, argument,
No, it's a deed. It's specific to real estate. Yeah, it's specific to real estate. How are we out of time? All right. So that's how you kind of how you would determine. I think the easiest way is obviously if you hear that somebody's passed away, that might get the wheels turning to maybe look into it. Looking at the property appraiser website, that's an easy way to also kind of identify it. And then those are some ways that you can actually avoid probate as well. So let's say that you go through the motions, you determine, the probate attorney, whoever determines, all right, probate is going to be necessary. So now you go and speak with the potential client. Hey, come on in.
sorry, I'm like.
No, it's all right. You're coming in for the second part. So, all right. So you determine that probate is necessary. Now, like I said earlier, you want to make sure that you're speaking with the right person. So, kind of the main thing is, what do you need to, this is where it gets a little bit tricky. Do you mind shutting down? That works. Thank you. Just not disturb them. All right. So one of the first things that you gotta know is that you're speaking with the right person. So what I always recommend is to ask two questions. So first, you want to ask, was there a will, and can you get a copy of it? And the reason being, again, if you're speaking with John, okay, and John has a will, and the will says the property is going to Sarah, or the personal representative to Sarah, well, then you don't want to waste your time speaking with John because he's not going to have anything to do with it. And sometimes people mistakenly believe, let's say John was the only son. He took care of Dad while Dad was sick. He's, sure he's getting the property. Well, Dad might have, had a lover, or Dad might have had, whatever, and he's leaving the property to a cousin or, whoever it is. And John might not know that. So that's why you want to see if there was and this happens more often than, not all the time, but it does happen a fair amount. Not the lover part, I don't see that. Not the lover part. But siblings, I see it, this is kind of like unfortunate, but sometimes I'll see where the will say, I leave everything to my daughter. I specifically do not want my son to get everything. And that does happen. So you want to ask if there's a copy of the will and see if they can get a copy of it. Ask if there is a will and then ask if you can get a copy of it. The reason you want to ask if they can get a copy of it is because sometimes people will say, yeah, my dad did a will, he put it somewhere, I'm not sure where it is, but I know I get it. And like I said earlier, if they don't have it, there's not like a master database that I can look in to see if there was a will. They have to have a copy of it. And so a verbal, I'm leaving this property to you, is not going to hold up in court. We'd have to have a copy of it. So ask if there was a copy of it. The second question I would ask is, what was your relationship to the person who passed away? So in relationship, I mean, was it your dad, was it your mom, was it your sister, brother, who was it? And the reason is, again, this is pretty common in Miami, specifically, or in Broward, I see it a lot, where you've got cousins living together, you've got, Theo and Thea who are living, whoever it is, you've got maybe not like close family relationship, close family, and if there's no will, there's a hierarchy of who's going to get what. So if there's no will in Florida, first your spouse is going to get it, then your children are going to get it, then your parents are going to get it, then your brothers and sisters, and it just keeps going on and on. But if you start getting to second, third cousins, chances are they're not going to get it, because the court is gonna have us find out, well, where's brother, where's sister? And even if brother is in California homeless, he might still be entitled to it, even though cousin was taking care care of mom and dad. So this is just a question I always encourage you all to ask, is just find out, who was the person who passed away? And the further in familial relationship they are, less likely that that's the person you're gonna be, working with.
Questions about that?
And again, so here now, why that's important. So again, I said earlier, the personal representative is the person who's able to sell the property. When you are working with someone, here's the kind of the tricky part. The first thing you want to get is a listing agreement, right? You want them to sign the listing agreement. Well, if they're not going to be the personal representative, it doesn't matter. They can't sign the listing agreement. So here's what I tell realtors. If no probate is open and no personal representative is appointed, let's say John is going to be the personal representative. You've spoken with the attorney, everything checks out. It's just a matter of, we need to get the personal representative appointed by the court. Well, you don't want to tell John, come back to me in 30 days and we'll sign the listing agreement, because chances are John's going to go right down the street to, the 10 other brokerages and try to find somebody who will, take the case. So what I tell realtors is have him sign the listing agreement as John Smith as proposed personal representative of the estate of whoever passed away. Okay, so this way, John Smith as proposed personal representative. So this way, you're kind of locking John in. John feels like he's, going to sign up with you. It's just a matter of time until he becomes personal representative. Now, and during that time, you can't list it on the MLS. Don't start marketing it. Don't do anything yet until you have. Just hold it. I'll talk about time frame here in a bit, but let's just say once John comes to our office and we get everything going, it's probably going to take us about 20 to 30 days before we get a piece of paper from the judge saying that John is personal representative. Okay? But, at day 1, you got the listing agreement, great, you're ready to go. Day 30, now we've got the personal representative appointed. Now, list it, market it, do whatever you want to do, and you can go under contract. I have no issue with that. And then, once you have him as personal representative, when you get a contract, he can now sign the contract as John Smith as personal representative. So anything that he does, he's going to be signing it as personal representative. And the reason you wanted him signing as personal representative is, let's say the contract falls through, for whatever reason, through no fault of John, it's just something happens, life happens. You don't want the buyer suing John individually, because it's not John's property, it's John's dad's property. You'd rather him, if he was going to sue the estate. So it's kind of protection for your client. I know that's like kind of legal and whatnot, but any questions on that? Yeah.
So the last listing I called on that was about to go through this probate process.
Sure.
I remember the realtor told me, the listing agent told me, it hasn't gone through the probate process yet.
Okay.
But I'm working with the heir, whatever, blah, 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 and so on and so forth. So technically that agent shouldn't have listed that property yet. Is it illegal to list the property until they receive the paper document from the judge saying this is the representative?
I don't know if it's illegal, but I don't think he has any authority to list it, because how can he list it? Because so like, yeah, so as an example, let's say he's still living, nothing happened. Let's say my dad passes away, okay? He wants to leave the property to me. Well, that was my dad's property. It's not my property. Even though I'm going to inherit it, I can't just sign up with you and say I want to sell my dad's property because it's not mine. I only can sell it once the judge says I'm the personal representative. So
There's no legal authority to sell the property
Right.
because.
it's not mine.
Yeah.
So I have to wait. So I don't know.
But
If
let's
it's
say-
illegal,
let's say
but-
this person is no condition in mind, and is a process done with a lawyer that he give you the authority to sell the property.
You could execute that.
Who doesn't have the owner
The
still
owner
living?
is still alive, but he's not in mental.
Well, then it's not probate. Then what you hope he has is you hope that the person that someone has power of attorney.
Power.
Yeah.
So that's.
But that would be before he died. So we're not talking about probate. I would not be able to do it for him unless he gave me power of attorney, which.
So basically, power of attorney and probate, the difference is
Well,
still alive and.
Yeah, a power of attorney stops when someone dies. So if I have a power of attorney for my dad,
Yeah.
I can do stuff for him while he's alive. But once he dies, it's no
And it
good.
goes to
then it goes through probate,
Probate.
and then you need the personal representative, and then that's kind of like the new power of attorney. The personal representative is kind of like the new power of attorney.
It's
Yeah.
the next step.
So now he can sell. So now let me give you, well, I need more questions on that. So that's like kind of the most important, as far as probate is concerned for realtors, there's not a whole lot different that you all have to do, other than kind of knowing the time frame, which I'll talk about here in a second, and how you sign those contracts. So the listing agreement, we said proposed personal representative, and then once the contract as personal representative.
So you signed one contract before
To lock them
to lock them in, just as proposed, and then
Yeah.
once it's gone through probate, you sign another contract that says
Well, you said,
personal representative
in.
of.
Once there's.
what I would say you do is, so the listing agreement that says proposed is not really, if someone wanted, I've never seen it, and we've done hundreds of these, I've never seen anyone, potential sellers sign a listing agreement with you, wait until he's personal representative, and then go sign a listing agreement with somebody else, and then say, well, that first one wasn't valid because I wasn't yet proposed. Is it possible? Maybe, but I've never seen that happen. You really want the proposed personal representative, the listing agreement, more so to get the client like locked in with you. So he or she is thinking, all right, I'm selling with you, I'm gonna list it with you, I'm not gonna, go find somebody else. Now, once they become personal representative, if you really wanna dot your I's and cross your T's, do a new listing agreement and just have him sign it as personal representative. And then the contract that he or she signs to sell the property, it's gonna be as personal representative. But the first one, the listing agreement before he or she is personal representative, is really just to kind of like solidify them with you. I mean, it might not be legally binding, but that's the best solution that I've found, and I haven't had any issues with it. So,
And if the proposed happens not to be the permanent, what happens? Then the permanent can choose another broker.
right, well, yeah, so that's important, yeah, that's why you want to, in the very beginning, make sure you're speaking with the right person. Yeah, so, and that's why, again, whoever, if you have your probate attorney or, whoever, look at it and kind of go through that consultation, with the client. So for example, a realtor recently referred us a probate listing, his mom had passed away, he's going to inherit the property. So, I didn't know her that well, but she had seen us do certain things or whatever, so she contacts my office, I have a consultation with the client, he had a will, there were 4 other siblings, I looked at the will, everything looked good, and I told her, I said, Adelina, good, he's going to be the personal representative, and then she got the listing, and then they signed up with her, and then she came in with the client, and we signed up the client
If
ourselves.
there's 4 other siblings, how do you know that that individual is gonna be the personal representative?
He was named, there was a will, and he was
Okay.
named in the will,
Alright,
yeah.
but it could just be anybody if
If
it's not named specifically, right?
If there is no will and there's 4 siblings, it's gonna go one of two ways. You're gonna want either consent from the majority of the heirs, so if we would have gotten consent from 3 saying that he could be personal representative, that would be enough. Or we file as if he's going to be personal representative, and then the other siblings have 20 days to challenge. So that's a little bit more technical, but generally, we kind of know who's going to be the personal. I mean, just by doing kind of our, what I know from the law and whatever, we can kind of tell who's going to be. But good question. All right, so how long does probate take? That's like, the main question a lot of, most likely your client is going to ask, and for you all, obviously, you want to, move this as quickly as long as possible. So there's really 2 scenarios. First, if the person died over 2 years ago, and then if the person died recently. Okay, and that's an important factor, and here's why. So let's say we're opening the probate now, 2019, but the person died in 2016, so over 2 years ago. Like I said, it's probably going to take about 30 days for us to get the personal representative appointed. Then, month 2, you guys are free, sell the property, that's it. So relatively quick, in a perfect world. Again, stuff happens. We've got one right now where there's a bunch of siblings in Israel, and it's just like, so stuff happens where sometimes I can't control that, right? Or we just finished one where there were 2 wills, and we're fighting, grandmother. Our claim, unfortunately, we won, was that she had Alzheimer's at the time when she signed the second will. The son was living with her, shady business, all of that. So sometimes that happens. But in a perfect world, 2 months if the person died over 2 years ago. If the person died recently, so let's say opening the probate in 2019, the person died in 2018. Still 30 days for us to appoint the personal representative, but then we've gotta wait month 2, month 3, and month 4, we can't sell the property. So there's 3 months that we have to wait. And the reason for that is there's a law, Florida law, where it's called a creditor period. So let's say the person who died owed money to Baptist Hospital, Mount Sinai, American Express, Home Depot, wherever. Any creditor has 90 days from the date that he was appointed personal representative to make a claim on the estate. So during that 90-day period, they're gonna notify me as the attorney and say, hey, John died and he owed us, $2,000 to American Express. Once that 90-day period is up though, all bets are off, now you can sell the property. So if the person died within 2 years, it's probably gonna be about 5 months before you can sell the property.
It's called the creditor period.
Yeah, creditor period,
So
yeah.
I had the case and, actually closed and they put it in escrow for 3 months,
So
for 90 days.
there are some exceptions.
Yeah.
And that, again, we have probates in about 17 counties, we're in front of a bunch of different judges, and I will say it's almost entirely county judge specific and some good legal work as well. If the property, let's say a lot of times there's foreclosure because if the person died, a lot of times with reverse mortgage, now they know, so now they're starting to foreclose, or there were HOA dues that aren't getting paid. Because generally, a lot of times the people inheriting the property have their own mortgage. They're not able to pay for mom and dad's mortgage as well. So sometimes
They have like medical expenses at the end of life.
Right.
They're sick.
Yeah, exactly. So a lot of times there are expenses, and they just don't have the money to keep up the property. Or there's other, circumstances that just require, hey, if this property doesn't get sold right now, there's nothing we can do. Then, again, this is kind of the exception, but if that's the case, then we can go to court and we say, hey, if we don't sell this property now, it's lost, and there's nothing we can do. And sometimes, yes, the judge will allow us to sell it, and we put that money into, it's like an escrow account, it's a restricted account, and then we wait that 90 days, and then we can do, you all would go ahead and get paid. So the realtor gets paid, your commission doesn't go into that escrow account, you all get paid, fortunately. We might not get paid, but you all would get paid, and then after that 90 days, then we continue with the probate and we'd be able to distribute it.
So you said that, say there's other siblings, they have 20 days to contest it. Do they have to be served by like a processor or a sheriff?
Certified mail.
Okay.
We just have to send certified mail. Yeah. Yeah.
So you said it was within 2 years of the person passing for the 90-day
Yeah.
creditor period?
Yeah.
2
Within
years.
2 years. Yeah. Within 2 years of the person dying and then us opening the estate.
Okay.
Yeah. So that's it can take longer, but I would say on average, you're looking with the person died over 2 years ago, probably about the 2 to 3 month period, and then if they died recently, probably the 5 to 6 month period, more or less. So that's time length. Cost, another big concern. A lot of people have questions about cost. I would say first and foremost, as a preference, I would say you all probably don't want to give them the attorney's fees. It's kind of like me saying, hey, I'm gonna refer you a client, he's gonna drop his commission to 1%. You're gonna be probably pretty pissed at me when that client comes in and says that. So I've had that happen. I mean, I don't have an issue giving a ballpark range because sometimes it's just natural. You wanna, sometimes clients just don't have any money and it's not, so you wanna give a range. But I will say, on average, most attorneys can charge one of 3 ways. They can charge a percentage. So sometimes Florida allows up to 3% of whatever the value of the estate is. So you can charge a percentage. Some attorneys will charge hourly. So, basically if I do an hour of work, my hourly rate is, $350. So I get $350 every time I do an hour of work. So that's one way. Or you can do a flat fee where basically just say, the entire process is X amount of dollars. Us personally, we generally do a flat fee. If it's not contested, if we've got siblings fighting over wills, then we're gonna do it hourly. I would say the range for most probates on the low end is probably gonna be 4,000, and on the higher end is probably gonna be about 10,000. So somewhere in that range. Sometimes, if the client doesn't have the money and they just don't have the money, you can do it at closing. Us personally, it really depends because I it's hard for me to guarantee my fee on closing because I don't know, I'm not a title attorney, I don't do closings or anything, so I don't know if there's a bunch of liens on that property. Or let's say I get title in John's name and then John says, nah, I don't wanna sell it, I'm gonna keep it. Well now, okay, great, I put a lien on that property, but when am I ever gonna get paid on it? Or I sue John who didn't have any money to begin with. So it kinda depends. If there's another common thing in probate is, let's say mom and dad had a bank account, mom and dad died, now there's money in a bank account which has to go through probate. If I know that I can get my fees out of the bank account, so maybe I'll do it something like that where I'll say, we'll do some sort of hybrid, but yeah, that kinda depends. Yes?
So to avoid probate, which is costly, the smarter thing to do would be to have a will, definitely, right?
Well, a will doesn't avoid probate. So going back, you missed the first couple minutes, but a will, a trust would avoid probate if done properly, or doing one of the types of deeds that we talked about would avoid probate.
The will not.
A will does not avoid probate. No, a will does not avoid probate. Big yeah. If you look at my business card, first thing I say on there, did you know that having a will does not avoid probate? Because a lot, yeah. So a will serves some function. There are reasons for function.
Who gets what?
Who gets what? And there's other reasons, but generally, yeah. You know, when it comes to cost, if you are a parent or you want to leave something to, somebody, it might make sense to pay for the trust and all that. But the truth is, some people just don't care. Some people are of the mindset, my kids are going to get it. It really depends on the person. It depends on, and it ranges from, people who just have one property they want to do a trust, or we were working with a estate plan with a client yesterday who has over 10 million and they have more complex stuff that they want to do. So it really depends. All right, since we're running low on time, last little bit. So how do you market for probate? How do you find probate listings? One of the easiest ways that I always recommend to realtors is if you were to go to the property appraiser's website, like we looked at earlier, you can search by owner. If you search under owner and you put estate of, so E-S-T-A-T-E, estate of, you're gonna get a list of a fair amount of properties that are owned by estates, okay? And that is kind of a easy, free way to pull your own data, and now you have their mailing address. And you could do some sort of direct mail campaign directly to those addresses. And again, we were talking earlier, this is a little bit more of a sensitive subject. Someone's died, so you probably don't want to come in there aggressive. Hey, I've got cash buyers, for this. You probably want to start with, hey, I'm very sorry for your loss. I realize someone's passed away. You may or may not know, but your property has to go through probate. I'm a realtor with X amount of years of experience. I also know how to deal with probate properties. Happy to help if we can. Something like that, where you're a little bit more compassionate about it. So that's a way to get, kind of your own list for that. There are also, I don't support one or know any specifically, but there are companies that will pull the data for you. So whenever whenever my office files a probate case, that's public record. So my office is my office address, my phone number is public record. Also, the personal representative, their information is public record, and a list of whatever assets are in the probate are public record. So you could either get that information yourself by researching, court records, or hire a vendor to do that for you, and you'll get a list of names and numbers. So I get solicited a fair amount by people who say, hey, Mr. Stivers, I saw that you're representing the estate of John Smith, and there's a property. Just wanted to let you know that I'm a realtor. I can help you sell the property. For me, that doesn't really work because I know, 1,000 realtors, so the miscellaneous, one. But for some people it might work, or for a personal representative it works as well, because sometimes the personal representative will get that same letter and then they're like, oh, okay, well maybe that will work. So it does work, so that's another way. Another way is, so the way I mentioned earlier, the realtor that I know who gets primarily all probate listings is she networks specifically with probate attorneys like myself. I frankly have never done a listing with her, but there is a monthly meeting at the Miami-Dade courthouse for probate attorneys, and she sponsors happy hours networking events because she's kind of like the go-to probate realtor for a lot of these attorneys. Because most of our, we have in-house right now about 150 or so active probate. Most of them are gonna have some piece of property. So you figure I'm one person with 150 potential listings more or less. You've got a ton of other probate attorneys. It's a good kind of network to get into if you can. So, we try to refer out as much as we can. So I work with, I'm not married to any specific realtor. The way I personally do it is I try to find realtors who I think would be a good fit for the client and or who focus on a specific area. For example, I am probably not going to refer a homestead listing to a realtor who focuses in Broward, right? So I try to, and I have realtors who say, I specialize in homestead to Orlando, and they're just kind of like, no way. So I try to find them who kind of like specialize on specific areas. That's pretty much it as far, so those are good, that would be kind of my tip for it, as far as how to network for it. But other than that, I've got cards, I have this handout, we do planning as well, so these are kind of, basic plannings, power of attorney, healthcare surrogate information, doing wills, these are kind of packages specifically for realtors, happy to talk about that with you all. But yeah, anything we can do, happy to help, and if we've got no more questions.
Thank you.
I have a couple para personal level.
Okay, perfect. Well, thank you all.